right, welcome back to your view. Our Frank Talk tonight is with Christine Qunta. Let's carry on. What did you find? I mean, did you find that the profession was so untransformed, right, as a result of maybe this division of governance, if you like, right? Advocates this side, attorneys this side. And is the LPC thinking that should change, not just change the fact that now you've got one body, but at some point be able to ensure that there are more attorneys who can just appear instead of having to go through advocates all the time. Of course, I'm aware that there are some attorneys that have a right of appearance, etc. But in general terms, people believe that only advocates have to appear in places like the Higher Court, Supreme Court, Constitutional Court, etc.
Yes. Post-1994, there was an act introduced which enabled attorneys to apply for rights of appearance, and they could appear in the High Court. The fact of the matter is, though, if you run an attorney's practice, litigation is very specialized. It consumes a lot of time. So most attorneys don't actually. I had rights of appearance when I was in private practice. I'm no longer in private practice, but I never went to court. You know.
So you'd rather get somebody who's a specialist.
Yes.
So advocate is more like a specialist.
Absolutely.
Right.
So advocates, that's all they do. So you tend to give it. But there are attorneys who actually do that. The issue around transformation and what we can do, if you look at those figures are not an accident.
Yeah.
And they're deliberate, like with all professions, whether it's accounting professions, engineering, you find the same pattern because of apartheid policies of excluding black people, not only from a quality education, but also even when they have that education, it's very difficult to get into these professions. So the LPC, maybe I can talk to you about what the Act says we have to do.
Yes.
So the objectives of the Act, which is in Section 5 of the Act, is we need to realize the goal of a transformed and restructured legal profession. And what that means, if you break it down, it means that we have to increase access to the profession. You know, it's very difficult for black people, especially, to get into the profession. There was a study done in 2014 by the Center for Applied Legal Studies and the Foundation for Human Rights. And they found that one of the biggest problems within the legal profession is the barriers to entry. And so the Legal Council, the LPC, if I can call that for short, has literally from the word go, decided on certain steps. And one of the steps it's decided to assist candidate legal practitioners, because remember now, all of them have to come in through us, is to first of all create a bigger pool of trainers. So at the moment, if you want to go to the bar, you go to the GCB. And the GCB has a very good training program because remember, you have to do what is called practical vocational training. So you do your degree, your law degree, LLB, and then you have to get practical legal training. If you want to go to the bar.
Like in an attorney's firm or something like that.
Well, if you go to the bar, if you want to go to the bar, you have to spend 1 year and do pupillage at the bar. And you don't get paid for that. But you train under an advocate, and the GCB has a very good program. If you wanted to go to the attorney's profession, you then have to get articles from a law firm, and you need to do that for 2 years, or if you do a 6-month special course, you do it for 1 year. But what you find is that before you can even get that practical vocational training, the course, you've got to get a contract of articles or pupillage. And there isn't capacity. Even if the GCB and law firms, the capacity is not there. So what we have done, the first step we've taken, is to expand the pool.
Of people who can train.
Yes.
Are these necessarily people who are in practice themselves?
Well, you see, you have law firms, you have advocates, and then you have certain institutions that don't fall within that category, and one of them is like the legal aid board.
Yes.
So you can be, and legal aid clinics.
Yes.
And we have special provisions that you have to have an attorney of so many years to supervise. What we are trying to do now is to look at more institutions that can take candidate legal practitioners
and
train them, give them articles. We also are expanding the advocates. So we're not just governing the people who, I don't know how to call them, they are independent advocates. So before they were advocates who were in the bar, and then they were ones who were not part of the bars.
Yeah.
So we're trying to expand that, and we're also trying to expand mentorship programs.
Yeah. So the access that you're talking about that is faulty is not really access to education in terms of universities.
No.
It's once you have an LLB degree, what then do you do to enter the profession? That's where the access is a crisis now.
Big crisis, and so many candidates who've studied for 5 years, or 4 years, they cannot get articles. So they basically stay at home.
With an LLB.
Which is really not very good. So we're working very hard. We're also talking to SASITA, which is a SITA, to see if we can get funding for pupils. So while
they are doing tutelage,
yes,
they can get some
money,
sustenance, money. Yes.
Because you can imagine, especially for those coming from poor homes, you've studied for 4 years, then you probably have a debt of your university fees. Then you go for a year with pupillage and you don't earn anything.
Yeah.
So what we are trying to do is to speak to SASITA and consider other options to see if we can get funding for pupils.
Yeah.
Because candidate attorneys do get paid, but it's not a lot.
By their law firms.
Yes, by the law
placed,
firms, yes. And SASITA already supports law firms and fund the salaries of candidate attorneys. But pupils don't get that.
Yeah.
So we're trying, so that's some of the measures we've taken to ensure that people get access. The other measure which we've taken, which is quite significant, is that before 1 November last year, if you go to the bar, if you do pupillage, you write an exam of the bar, and if you go to the attorneys, you also write separate
exams.
What we are trying to do now, and we have to change the regulations. So we've taken the first step. We've discussed it with the Department of Justice. We want to create a uniform course. So within that pupillage and articles, you do only one practical course, which is 5 weeks. And whether you go to the bar or whether you're an attorney, you do the same course and you write the same exam, which is quite significant. But for that, we have...
So what will distinguish attorneys from advocates then if they write the same exam?
The reason why we are doing this one is we are hoping that, and we've proposed an amendment to the Department of Justice. So when you finish your law degree, even if you don't get articles, we are hoping that you can do that course, that 5-week course. That course can then make you more marketable. You still have to get articles and you still have to get pupillage.
I see.
But it might make you more, you've learned something practical, and so that you don't need to have a contract of articles. So you're not sitting at home.
Yeah.
So we're working on that.
I say that could then open doors for example, legal advisory work, things like that.
Perhaps.
They don't require you necessarily to go and appear in court.
Yes, to be an admitted thing. Yeah. But we believe that it will do that, but it will also allow you to move between the two professions easily. So you might do pupillage and decide, actually, I don't want to be an advocate. I want to go and be a lawyer. So you write one exam. You don't have to then
go and do a separate exam because you've said you change
the
route.
Course. You don't have to then go and do that course. So we're hoping that all these measures will assist with access to the profession.
And it makes the profession a lot more efficient. So are you saying that kind of reconfiguration of access and so on can also ensure that more attorneys could also themselves then apply to appear, because then in a sense they are moving from the same knowledge base?
Yes, but remember, as I said, they can appear now. They already have rights of appearance, and so there's nothing barring them from continuing to do that.
Yes.
Yes.
In terms of the whole gender issue, I mean, did you find that there's a very huge
big
gap
problem
in terms of
problem.
gender disparity in the
Big
profession?
problem. I mean, I don't even want to, I think African women constitute about 3,000 out of that 32,000 only. And so there's a major, major problem. I think white women are better. They like five or 6,000. But if I want to make a practical example. You remember the NPA appointed 4 male senior counsels to prosecute cases coming out of the State Capture Commission. I mean, that was a very outrageous thing to do. It really shocked us. And I know a group of women practitioners have written to the NPA and the president to object. So if you look at all the major public cases, you really see senior counsel, and they're very competent female senior counsel. You don't see them, you just see men. So there's a major gender problem. And what we've done now, which is the other thing, so I'll come to that just now. So people have a problem with access. So you finish your law degree, you struggle with access, primarily black people.
Yes.
But even if you get through that hurdle, when you now go into practice, you're faced with a problem that the private sector prefers to continue to procure services from white firms. So they're continuing as if apartheid never, as if 1994 didn't
never
happen.
happened, yeah.
So that is a major problem, so that black firms and black advocates really struggle. I can almost understand the white firms, that they are resistant to change. But what the problem is that government is also at fault.
Yes.
Government...
You go and also procure white
from
advocates.
white firms and white, you know, you hear of white firms from the SOEs, they are earning 21 million over 2 or 3 years, and no one bats an eyelid. But if a black firm earns $1 million or 2 million, there's a big braho in the media. So there is an understanding that black firms are not entitled to even government work. And government tries. They have procurement policies, but then they also don't pay people on time. So black firms are really, really disadvantaged. So what we've done as the LPC, we have initiated a process to start to do a legal services charter, BE charter, because we think that's the only way.
Okay, let's pause there. I want to come to that, be a possible BE charter within the legal profession. Clearly, even if you look at constitutional court cases, you know, who represents, you know, parliament or even the president at some point, etc., you are surprised whether or not, you know, there's a mentality of transformation even in the government in terms of how they procure legal services. We're talking to Christine Qunta, and after the break, we carry on more and talking about transformation in the legal fraternity. Let's take a break.